Welcome viewers to the Personal Injury Law Show. My name's Tony Carbone, personal injury lawyer of 25 plus years experience. This is season 8. Welcome viewers to the show. Next to me I've got John Carancis, accredited law specialist. Good evening, John.
Evening, Tony. Evening,
What's that
viewers.
mean in brief?
Accredited specialist in personal injury law, Tony. I've been accredited as a specialist. I've been recognised by the Law Institute of Victoria as one of the leaders, I guess, Tony, in personal injury law.
That's a no mean feat. And next to me I've got one of the youngest partners in the law firm, Nuncio Tartaglia. How are you, Nuncio?
Good evening, guys. How are you, viewers?
It's our 8th season, so, you know, we're starting to get some...
Over 90 episodes, I understand.
Plus,
so,
yeah, 90 episodes plus.
And Tony, before we get into tonight's show, what's in the news?
Well, John, tonight we're going to be talking about disputed wills and death claims, and what's in the news is this ongoing saga between the Pratt estate and the so-called ex-mistresses. Now, there's two at the moment in Sydney court trying to claim a chunk of Mr Pratt's estate. Apparently Mr Pratt had a mistress with a young daughter and he made provision for her, and the other two daughters that Mrs Hitchcock had, they were made provision for as well.
And this is a claim for multi-million dollars, isn't it,
There's a lot
Tony?
of millions at stake here. And the other mistress, she's apparently settled her claim for about $100,000 a few years ago, and now she's having a second bite at the cherry.
It's, from what I understand, Tony, it's a lot of salacious details that have come out in court.
It's very, very interesting. And Robert Richter, very learned senior barristers in court, cross-examining Mrs Madison.
I think this could go on for a long time. It's one of those things that won't resolve very quickly.
Well, from what I understand, the lawyers acting on behalf of the Pratt family made an application for the case to be dismissed.
Yeah, look, I thought there was a release, but it sounds to me that there was only messages and emails passing between the parties, so... It's
alleged that she agreed to terms, but it hasn't really came out at this stage, so...
And look, why don't we come back to this later on, because the show's about disputing wills and things like that, so let's get on to the show so that we don't waste too much time, but... tonight what we're talking about is disputed wills and people that are left out of wills or provision hasn't been properly made for them. But before we do that, John, there's a lot of instances in work accidents and also car accidents where people are entitled to a no-fault benefit. What's that mean?
Exactly. Under the Victorian Work Cover legislation, a dependent of a worker that dies at work or in the course of work, Tony, they're entitled to no-fault benefits. And
what sort of money are we talking here, John?
The lump sum is quite substantial, Tony.
Could be up to $500,000 plus?
$500,000.
And is it based on dependency?
Based on dependency, exactly, Tony.
And there's also pensions attached to it as well, isn't
And
it?
pensions for the children.
Okay.
So, and that's a no-fault benefit. If your partner dies at work for one reason or another, and it's just a shocking time for everyone when that occurs, you are entitled to make such a claim.
And there's mirror provisions in the Transport Accident Act, isn't there?
Exactly,
yeah.
Exactly.
And also, the other thing, Nuncio, is that under the Transport Accident Act, along with the work cover system, you're entitled to pensions until children finish schooling, which is secondary schooling and also university.
Correct.
And the other decision a lawyer has to make is whether you bring a common law claim in these circumstances, John.
That is something that a lawyer must assess, because a lot of times you'll find that the statutory benefit, which could be $500,000 plus, will suffice, won't it, Tony?
Yeah, well, that's right. I mean, a lot of it depends on negligence, whether you can prove negligence, to the age of the deceased and what sort of money he or she were earning. So they're very relevant considerations.
And a lot of these matters do end up in court, and you need to actually have, even if it settles, you still have to have court approval, don't you, Tony?
Yeah, that's if you go down the common law path.
Exactly.
Now, Nuncio, in superannuation, is there any special provisions or is it similar?
Yes, so look, there are death benefits under most superannuation policies. They vary in terms of the amount of damages or quantum. And also it all depends on the policies and also whether there's been nominations in the superannuation policies. We've had this discussion before where you really should leave a binding nomination under your superannuation policy.
So are you saying that a death benefit under a policy doesn't go according to a will?
No, it doesn't. So the trustee, the superannuation fund, they have the discretion as to who the money should be allocated to and the amount of money should be allocated to. So it's very important that, again, you look at the terms of your policy.
Nuncio, if you put a binding nomination down, can the trustee get around that?
Oh, I think they can.
They probably can, but it'd be very difficult if you've made that provision. But more certainty if you do, though.
Isn't it based on needs? Who's got the most need?
Exactly. Yeah.
Yeah.
I'll support and economic needs and every situation is different.
What happens if someone dies intestate, that is, without leaving a will, Nuncio?
Well, if someone dies intestate, so there's usually the estate is allocated to either the partner, the spouse, the kids, the family, whoever's obviously the next of kin, I suppose.
There's a formula, Tony. Isn't
Someone's
there?
got to put up their hand to act as an administrator, so that the paperwork gets done.
And
obviously,
the executor.
Yeah, the administrator's the terminology we use when there's no will. So what happens is it's usually the person that thinks they're entitled, or most entitlement.
Yes.
Now, let's say probate goes through, or letters of administration, that is in a case where there's no will.
So we're talking about a situation when there's no will, Tony.
Yeah, there's no will, or there's a will. Let's say probate's gone through.
All right.
Or there's been no will and administration's gone through. In these circumstances, can you contest the probate, Nuncio?
Look, you can. There's varying instances when you can do so. Generally occur on when the will's been administered incorrectly, when there's been undue influence in executing the will, there's been sort of undue pressure, and also when there hasn't been an adequate provision of,
Well, that's what we're interested in tonight.
Proper care and maintenance.
That's what we're talking about tonight, viewers.
And I take it anyone can contest a will, Tony?
Well, there's got to be that sufficient link. It's got to be someone in need. I think the key to it is you've got to have dependency. Needs, is that right?
And some economic support.
And just on that point, John, what are the factors that the court looks at? There's the Administration and Probate Act 1958 and it's Section 91.
There's various factors, Tony, but even the character of the applicant, Tony. But in the end, I think it all comes down to financial need.
Is that what it comes
of the
down
applicant.
to? Economic needs?
I think that's what it comes down to, Tony. That's a major part that the court will look at. As
Okay,
to whether or not you are successful and whether or not the deceased had a moral obligation to take care of that applicant.
So in other words, if the next door neighbour or the person up the street says, he promised to look after me, are they entitled, John?
Well, you need to get into a bit more details as to what's this promise and why would there be such a promise.
Look, it's going to get nice and juicy and interesting. So viewers, we've got to go to a sponsors break, so please don't go away. Stay tuned. We'll be back shortly. Thank you.